So hello, everyone. Thanks for attending. My name is Jordan Elliott. I'm a associate attorney at Husch Blackwell. I'm in our corporate PSC. So what I do is deal with startups all day. I deal with pretty much all things related to business law, do commercial contracting, business formation. We do fundraising, and then a lot of M&A too. So really all stages of the entity cycle from beginning to end, we cover, and I've seen it and have pretty good experience in all of it. Just off the top rope, I am an attorney, but I am most likely not your attorney yet, unless we have a prior engagement. So this is all general advice. I assure you it is good advice, but it is, important to consider all of the facts in your specific situation before, relying on anything that's said here today. So off the top, so this is failure to launch, a very cleverly named PowerPoint here, just about common issues facing startups. So we're going to kind of go with a survey of things. One is really why it's important to incorporate or organize. I'm sure given the audience here that many of you actually have your own LLC or your own corporation, but for those who may not and are thinking about starting a business, we'll just go quickly summarize, why it's important to do that and what legal protections it gives you. And then secondly, we'll just go in some of the kind of boo-boos that I've seen happen across a lot of different entities in my experience, and things that can really kill startups from a legal perspective, right? I mean, we've seen good ideas go to waste because they've run into a snag on one of these fronts, which I'll discuss. So without further ado, the first slide here, so the question is why organize, right? Why make your own business? And the biggest item here is this idea of limited liability protection. And so if you were to just start your business without organizing an LLC or a corporation and running it through that, you have created what we call a sole proprietorship, or if you're doing it with another person, a partnership, right? These things just happen automatically under the law. No need to file. It's quick and easy, right? But you do not have limited liability protection and you don't have a separate existence. So what limited liability does for you is it basically puts a wall up between you as an individual and the business that you're running. So if you are running, this is the example I used yesterday for this same presentation, so I'll carry it forward, a lemonade stand, right? And you go outside and you sell it, and it's Jordan's lemonade stand, and I hurt somebody with my lemonade because I didn't make it correctly or safely, and I'm just doing it without a corporation or without an LLC. I have now put my house, my car, all of my personal assets at risk, right? If I did it through an LLC and I observed some formalities that we're going to talk about later, and I had the right insurance and I had the right capitalization and I did everything right, I really only put the assets of the LLC on the line. So the biggest thing, the first thing, is that you're creating a separate legal existence and you're shielding liability of the business against your personal assets. And that just gives you a higher toleration for risk, right? I mean, you can take more chances, you can do more things because you know that you have a little bit of a safety with the limited liability protection. I just hit on a little bit, creation of a corporate identity and perpetual existence. If you don't have a LLC or a corporation, and let's say you unfortunately pass away, the business does too, right? There's no way to really continue that. One of the nice things about an LLC or a corporation is that it exists without you, right? It is a complete separate existence. The last 2 points here are pretty obvious points, but really important in the context of startups. The transferability of ownership, and you have a greater flexibility to raise capital, and those really go hand in hand, right? As an organized entity, as a corporation, as an LLC, you have the option to issue equity, to more easily create debt instruments, right? To get capital into your business, to get your idea really off the ground. So those are just really quick 4, things that are the big things that a organized LLC or a corporation will do for you. Does anyone have any questions on this slide? This is like starting at the very top of the iceberg. But if you've got any questions anytime, please feel free to, just speak, or you can let me know through the chat. And if I don't see it in the chat, just then put the microphone on. But any questions at all? Okay, let me know if you do. So quickly, just the types of business entities that we see most commonly. So the first two you'll see are not underlined, right? And the bottom ones are underlined. That is to signify an important distinction between the top two and the bottom items. And that is the bottom items are the items in which you have limited liability protection, and the top items are ones in which you do not. So the sole proprietorship and the partnership, again, created just out of your actions, not necessarily through any filing with the state. No limited liability protection. Basically, it's you running that business and your assets are on the line. A corporation is formed by filing articles of incorporation. It's one of the most common and most popular startup entity types. Second, I would say to the LLC. And the LLC is a newer form of an entity that's really based more in contract law. So it gives the owners and the organizers of the entity a wider array of tools to agree on how the entity will be run. So basically in that, you will execute an operating agreement with your partners, if you have them, and that will really detail exactly how the entity is going to be run. A corporation, corporations have been around for hundreds of years, right? And so there's really specific requirements each state have on how they must be run. So an LLC can help you sidestep some of those requirements, maybe some of the more what we would consider archaic requirements, but still get you to that limited liability protection. A limited partnership is not as common as an LLC in the startup context, but it's still done. Very similarly as to an LLC is how it's governed. You have to file with the state to create a limited partnership. And then a not-for-profit or a nonprofit corporation is just a corporation, right? It's just the same old corporation that you'd file anywhere, but in each state, there's a process to be recognized as a nonprofit, and then a lengthier process to be recognized as a 501c3 charity at the federal level, both of which we do a lot, but again, it's not really the focus of startups mainly. So we won't be talking much about nonprofits today, and really we won't be talking much about limited partnerships after this slide. So one note, I've got the S Corps slide up, and you'll see that we have that under corporation. So a lot of people think that a C Corp and an S Corp are really different entities, and it's understandable why, but it's not technically true. So they're both corporations, they're formed the same way. An S Corp election is just an election you make with the IRS. And there's certain requirements. So you have to have less than 100 shareholders. They have to be natural persons. There can only be one class of stock. But if you fit those categories, and I think there's a few others too, but if you fit those categories, the neat thing with an S Corp is that you can then be taxed on a pass-through basis. So instead of being taxed for the corporate tax, you now are being taxed like you are an LLC or a partnership. So if you have more than one owner, you're taxed as a partnership. If it's just you, then you're taxed at your pass-through rate. Any questions here? I promise we'll get into some more meaty stuff, but this is just kind of setting the stage. Seeing none. Okay, so basic organizational documents. We're going to pivot at this point and really focus only on corporations and LLCs, which again are by far the two most popular forms of entities that we see, especially for startups. Typically, it's what we see any startup structured as. We rarely see any new startups as a limited partnership. Limited partnerships are important in the startup context only because a lot of money flows from limited partnerships. So a lot of investors are invested and incorporated as limited partnerships, but not usually on the operating company level. So you have three main documents for a corporation. One is your articles of incorporation, which that is a document that's filed with the state in Missouri. So, well, in any state, but we'll go with Missouri as an example. So in Missouri, you would file these, and these articles detail very specific and enumerated things that have to be listed, but they can list a whole lot more than that, right? You can really basically dictate how all of your corporation is going to be run through the articles, right? The downside in doing that in the articles is that it is a public facing document. So anybody can pull up on the Secretary of State's website in Missouri, any corporation that's registered in Missouri, registered to do business in Missouri, and see kind of those internal governance things. So typically, we advise clients only to put the statutory requirements on there. And if there's, special circumstances, sometimes there's other reasons why you put more information on that. So that leaves the question, how does how is the corporation to be run, and what exactly are the rules and voting thresholds and that. So that's where the bylaws and shareholder agreement come in. Bylaws are adopted by the corporation, and a shareholder agreement is adopted by the owners of the corporation. They can do similar things. Bylaws are kind of they're getting closer and closer to like a form document that, don't deviate too much from corporation to corporation. But shareholder agreements are really flexible. It's just a contract between the shareholders that dictate how items are going to be run, how decisions are going to be made, who's going to make the decisions, and everything about the corporation can be put into here. Typically, if there's any conflicting terms between the articles, bylaws, and shareholder agreement, it will be decided in that order that you see here. Articles will typically trump bylaws, will typically trump the shareholders agreement. And then LLCs. So the Articles of Organization is a similar document to the Articles of Incorporation for a corporation. But the Articles of Organization are set forth the LLC document. In Missouri, set forth the LLC name and separate different things about the LLC. One of the most important things is how the LLC is going to be managed, whether it would be member managed or manager managed. Those are two different management structures that in Missouri, you have to designate which one you are. And so typically we advise if you're just a single member LLC, just a single owner, and depending on the facts, member managed seems fine. If you have more than one owner, then a manager managed scheme may make more sense. At any rate, the articles are publicly filed. Your operating agreement is not. That is close to the same thing or akin to a shareholder agreement. It is an agreement between the owners of the company and often between the company itself on how the company is going to be run. And so this is basically setting the stage for the rest of the discussion, which is we're going to talk about provisions that go into your shareholder agreement, into your operating agreement. In what I've seen, people miss that can cause big problems later. I think the rest of the presentation can be fairly summarized as how not to mess this up so bad that you end in litigation with your partners, right? Yesterday when I did this presentation, there was a question about, well, do you need a very long, complicated operating agreement if you are a single member, so a sole owner of an LLC? The answer is no. We have, typically recommend that you do have an operating agreement, but it's very straightforward. So for the rest of the conversation, we're really going to be talking about corporations with two or one or more owners, or LLCs with one or more owners. So that's kind of where we're at. Any questions right now? I know this is kind of, if you've gone through this song and dance before, this is really just a surface level discussion, but I want to make sure if anyone's got a question, they have a chance to ask.
I guess just for context, if I hadn't incorporated in the past and I was just starting with knowing that these are my two options, what would I choose between to pick?
Yeah, so that's another one that's really dependent on your facts, your circumstances. Okay. But what we typically see, right, is an LLC, right? An LLC is the most flexible. If you're the single owner, I would definitely recommend that, especially in Missouri. If for no other reason that Missouri doesn't require annual filings for LLCs, so you can file it and then basically, unless you need to update something about your filing, really leave it alone. A corporation in Missouri requires, in some cases, annual reports, some cases biannual reports. So, you can sidestep a little expense and hassle with the LLC. Plus, it's just easier, right? I mean, for a corporation, you have articles, you have bylaws, you have shareholder agreement. In your case, you wouldn't have a shareholder agreement as a single member. But you'd also have to figure out if you want to issue shares of stock. They don't have to be certificated, but often, people do like that. An LLC, it's just a very simple operating agreement, very simple articles, and a lot less logistical hassle. So I always lean that way unless there's, a compelling reason, whether it be a tax reason or it be some sort of, a lot of different government programs require a corporation, not an LLC or something like that. So it gets to be pretty fact intensive, but, just generally, I always lean to LLCs because you just have so much more flexibility.
Awesome.
Great. So common issues at the formation stage. So This is talking about basically turning in your articles of incorporation or organization to whatever state you're going to organize in and creating your entity. And we see this a lot, right? People take this step for granted because it's the first step and it is a pretty simple process, right? But then something changes with the organization and you don't go back and amend those documents, or you didn't get it right the first time, and it's time to go up with an investor and they realize that you're a manager managed LLC and you're operating, sorry, in your articles of organization, but you've been signing all of your documents as the member, right? And there's an argument that you didn't execute your contracts correctly, so nothing's enforceable, and they get scared and walk away from the deal, right? These are obviously extreme examples, but real issues. So the first item is where to incorporate, where to organize. In the past, we've seen a preference for Delaware, right? The Delaware courts are very good and have been very good for a long time and have a well-developed body of law. And so there's always kind of this preference to go to Delaware to start your corporation. Delaware is expensive and, in my opinion, kind of a hassle to keep up with. And if you're not operating in Delaware, you don't really have many advantages to go to Delaware. One of the advantages is that investors typically are, historically, we're more comfortable with Delaware corporations and investing in them, understanding them more. In our experience, that's just not really the case anymore. I've never seen a deal go through or fall through, sorry, because someone was incorporated or organized in Missouri. So when you're thinking about where you're going to start your business, where to incorporate, my advice is really think about where you're going to operate, at least initially. If you're going to operate in all 50 states, it may matter less, right? But if you're going to have a physical presence in any state, and there's different tests to determine whether or not you have a presence in a state. But generally, if you hiring employees, if you've got an office in a state, if you're operating in more than one state, I would always pick the state that you're in to incorporate in. And the reason is that for every state you have an office, or every state that you have to hire employees in, you do need to register with that state and be qualified to do business in that state, right? And so if we're thinking about how to avoid problems early on, let's say most of your business is in Missouri. Well, if your employees are in Missouri, your office is in Missouri, all of your assets are in Missouri, to me, it doesn't make as much sense to register in Delaware and then qualify in Missouri rather than just registering in Missouri. It's additional expense, and it sets up the trap for you later that if you just qualify in a foreign state like Delaware and don't qualify where you're actually operating, you can be hit with fines or penalties or problems in that realm too. This becomes problematic like in an M&A context, because in any buyer of a company will ask, hey, are you qualified to do business in all the places that you should be? And if you don't think through this step appropriately, you won't be able to give that rep, and it can be a major red flag. One of the other ones I've seen that's basically confined simply to corporations is that the authorized equity is something you have to state in the articles of incorporation, right? You say there are this many shares of stock that can be issued. What people do oftentimes is say, okay, 1,000 shares of stock can be issued. And then the first thing to do is they issue all of themselves, all of the 1,000 shares to themselves. So they've now taken all the shares off the books, put them to themselves. That's fine, right? You're the sole owner, it works. But they meet a partner or have an investor or have a reason to issue equity to someone else. And without going back to the articles of incorporation, they issue more stock, right? This can be kind of a latent, unseen problem for a long time, right? Until you meet an investor or until it's time for more funding and someone digs through your documents and sees that you've improperly issued shares. And there could be an argument that they were not, issued validly, right? And then you've got big problems, right? You've got somebody who thinks they have ownership, that their shares are being called into question, and then your cap table's messy, so the investors are getting a little squirrelish and maybe go away, right? So that's just another thing to think through, that you don't necessarily want to issue all of your equity right away, and if you need to, always be aware of how much you can authorize to issue, because you may need to go back to those articles to amend that. One other thing, this is kind of tax adjacent and just, standard disclaimer. I'm not a tax attorney, but know enough of this to have seen it, and it can be really devastating. You have to elect to be an S Corp. It does not happen automatically. A lot of startups intend to do this election, but maybe forget or don't do this, and even file as an S Corp, right? And it may not trigger problems for years. It really may not. But when it comes time for a refinancing or a sale, your buyer is going to ask you to give a rep that says you've been filing taxes correctly, or your lender might, or an investor might. And they're going to do due diligence and see that you didn't actually file as an S Corp. And this can create a huge back tax issue that is super expensive and takes a lot of legal time and accountant time to settle through, right? So if you've received advice from your attorney or your accountant that the S Corp is the appropriate fit for your business, and you want to make that election, make sure you do that. I believe you have to do it within 45 days of creating the entity. I think there's some extensions for that. And I think it's possible to do it each year, make an election and then discard that election a different year. So it's a year-to-year thing. But the important thing is you have to do it, right? It just doesn't happen automatically. So the DIY options, right? So this is a little bit like letting the vacuum salesman come in and tell you your carpet's dirty, right? So, standard disclaimer there, but LegalZoom and DIY options are not the worst thing in the world. People use them effectively, they cut costs, and oftentimes they kind of get the job done. But I've seen all three of these issues that I've highlighted above with LegalZoom, or at least the first two, right? And I think a lot of time what happens is LegalZoom documents, you don't have an attorney there updating them or advising you, oh, if we want to change this, it's time to go back to your articles to revise, right? So you just have to be extremely careful with those options, especially when your startup gets some traction and you start making some progress with whatever business you're moving. You don't want to have some silly issue with the formation really trip you up. So I would definitely recommend if you've used a DIY option, if you're doing any significant changes to your business, to contact an attorney and walk it through to make sure it still makes sense. If you're nervous about any of the things I talk about today, contact an attorney, accountant, somebody to just walk through those initial formation documents and really make sure it lines up with what you're doing today. Any questions on this slide? Don't see any in the chat. Okay. So here's some organizational planning tips. These are just common provisions that I see in a lot of really well done operating agreements that are omitted in a lot of operating agreements that may not have kind of the right advice and planning going into it. So again, your operating agreement is in an LLC. It's the document that says exactly how your company's going to be run, who's going to make decisions, how those decisions are made, how many meetings a year you have to have, things like that. In a corporation, this would be scattered among the bylaws and the shareholder agreement, if there is one. So again, it's the mechanics of the organization. So the first one is the failure to include like a tag along and drag along. And so I think, fairly, this is the part of the presentation where if the first part was very boring because you've already done it and those things, these are, this is kind of where I think some of more of the intermediate steps kind of kick in. So a tag along and a drag along provision, I think, is pretty essential in any operating agreement or shareholder agreement in which there are more than two members or two owners of the entity. And essentially what it is it's a mechanism that we insert that allows the company to be sold as a whole and prevents the company to be being sold piecemeal, right? So let's say I have a partner in my business. I own 75% of the business. They own 25% of the business. I get an offer from a buyer who's said, Jordan, your business is great. We'd like to pay you a premium for the entire thing, right? We're going to pay you, too much money for your business. And I say, that's awesome. Let me go to my partner. We're going to sell to you. And I go to my partner and the partner says, no, I'm not going to sell. I think that price is too low. And I go back and say, hey, look, my partner's out, but I'm still in. Well, the buyer, it's not attractive to buy 75% of a company, right? Buyers typically want to buy an entire company. There's obviously exceptions to that, but that is a pretty common goal, to get control of the entire enterprise. So what a drag along provision does is a right to protect the majority shareholder, to say, hey, if I get an offer to sell and I sell, I can force you to sell on the exact same terms, right? And typically, whenever there's a drag along, there's a tag along, right? I mean, it doesn't have to be, but most negotiators will say, okay, if we're giving you a drag, then we get a tag. It's just the opposite. So if I go and say, hey, I'm selling my 75% stake, the buyer didn't offer you 25% owner anything, the 25% owner can say, hey, look, I'm going to tag along in this sale, and the buyer has to take 100% or nothing, right? I have that right. So what this does is keeps your company marketable to buyers, right? And I think that's really important, right? Because startups tend to take on partners quickly. And sometimes those partners add a lot of value. Sometimes it doesn't work out and they're there just to hang out. And we've seen that happen time and time again. And so what the tag and drag does is it keeps that possibility of 100% sale, which is really important for getting the value out of your enterprise. Breakup provisions. So yeah, this is like the prenup part of the talk, right? Where you're going in with your investors, with your co-owners in a venture. And of course, the good deal defense says, as long as everything works out, everyone's happy, right? That doesn't always happen, right? People tend to think there are different ways that a business should be run, or have disagreements about the direction of the business. So what breakup provisions do, there's lots of ways these can be done, but it basically provides an orderly mechanism to split up, right? Who's gonna buy the rest of the person out? Who's gonna sell their stake? One of the ways that we typically see this done is called a buy-sell agreement. And a lot of people have probably heard of a buy-sell. A buy-sell agreement can be its own agreement, or can be incorporated into a shareholder agreement, or bylaws, or an operating agreement for an LLC. And the premise is, and there's so many ways this can be done, right? The premise is, if we need to break up, it's time for us to part ways. I can go to you and offer to sell you, or offer to buy your shares for a certain price. So I would say, hey, I'm going to buy your shares for X dollars. And then the recipient has the option then to either say, you know what, I'm going to buy your shares at that price, or yes, I will sell you my shares at that price. So it's a quick way to get a fair valuation, right? The person who wants to buy has every incentive to give a little bit of a premium to sweeten the pot for the person they're trying to get to sell. There's lots of ways to do valuation here, though. You can bring in a third-party accountant to actually perform a valuation. I've actually seen an agreement, a way to break up is basically just based on the evaluation, and then it's a coin flip on who gets it, right? It's can be wild, and there's a lot of freedom here. But it's important to really think through kind of an organized way to get out of this a business together, and also a way that's not too accessible, right? You never want it to be so easy that it's kind of everyone's first option. Well, let's initiate the buy sell, right? So it can be a delicate balance, and one that I think all of these provisions are definitely in get an attorney to help you category. The next item is restriction on sale. This one's really simple and straightforward, but if you do a simple single member LLC operating agreement and then admit another member, you may not have this, right? Which could be very problematic. So most organizations we help organize have a restriction on sale of the equity. So you are prohibited from selling your equity without getting approval from the other shareholders, or a majority of the shareholders, or a certain percentage of the owners. And this is really just to keep, one, the business intact, and two, kind of amongst friends, right? You go into business with certain people, if something goes sideways, you really don't want someone being able to sell to someone who's going to make your life miserable. And so we always recommend that restrictions on sale be put on equity of any organization we help advise. Another item is vesting. So we see a lot of this, right? You give equity to somebody over a certain period of time, or you give equity to someone if they meet certain key performance indicators or whatever. You know, there's a lot of flexibility in how you can bring someone into an organization as an owner and have their shares or their membership interests, if it's an LLC, vest over time. What we see a lot of is that the vesting provisions are really poorly drafted or not drafted at all. So it's kind of like an email agreement. Hey, you're going to get these shares over 5 years. Well, do I get half of them in the first year, or do I get them evenly over all 5 years, or how is that going to work, right? Whenever you're going to use a vesting mechanism, there's no shortage of detail that you can incorporate. And really, I think you're doing yourself and your company a disservice by not thinking through exactly how things should be vested. So really defining those KPIs, if it's a performance indicator based vesting schedule, they have to land 3 new accounts before this happens, right? You really have to be careful with that language. If it's over time, it has to be really, really precisely drafted on exactly how it works. So if you're doing any vesting in your business, or you have any equity that you yourself own, right, that's subject to vesting, make sure that it's very, very clear, because this is one of the common ways, right? You can imagine if a sale happens and someone's only vested at a small percentage, but they think they're vested at a higher percentage. One, that can create a lot of problems between you and that investor. 2, it can jeopardize the sale of the business. So you're going to lose a lot of value that way and scare off buyers. The next item is just voting thresholds and tiebreakers. And so this is just, if you have 2 people in a business, right? And you say it takes a majority of the shares, or it takes 50%, I should say, of the shares to approve or disapprove an action. Well, what does that mean, right? If one person votes one way, one person votes another, that's 50% approving and 50% disapproving. So you want to think through how many owners you have, what the voting threshold should be, and then any tiebreaker provisions, right? Because you don't want to get stuck. That's the real danger here, is that the organization gets stuck in a way in which it can't make decisions. The managers are not allowed to make decisions, and you're completely at a stalemate. So there's plenty of ways we can handle that too. The good old coin flip happens there, but there's lots of really good, more sensible solutions, like appointing kind of a third-party advisor to be the tiebreaker. We see that one a lot. Someone that's trusted. It could be an accounting firm. It could be someone that's a advisor to the business, or maybe a mentor. So think through that, right? As you're thinking how this business is going to make decisions, think through how can we get stuck in making a decision, and what are some mechanisms that we can put in place to reduce that risk. Any questions on this? I know this was a lot. This slide was pretty heavy. Okay. So the next item I would say that we notice a lot of startups, and this is completely understandable, right? You're a startup enterprise, you are lean, you're mean, you've got an idea. The last thing you really want to do is be bogged down with a bunch of corporate stuff that you may not understand or care to understand, and that you've hired an attorney to deal with anyways. So what's the point? That can be really detrimental in the long run. And so the first point here is just observe corporate formalities. That tip applies to LLCs or partnerships or any entity that you organize. But the idea here is that the law is giving you a really great advantage and tool in affording you limited liability when you organize a company, right? You are protected and allowed to go out on a venture and shield your personal assets should there be any liabilities coming from that, right? That's a pretty powerful tool that the law affords you. But to keep that tool and to preserve that tool, you have to observe, what we'll call generally corporate formalities. That's having meetings, regularly appointing directors. If your operating agreement of your LLC says you're going to do X, Y, and Z every year, do X, Y, and Z every year. Having the right amount of liability insurance, properly capitalizing, right? If you are, chartering flights, through an LLC, right? But you have no insurance and the bank account has no money, and you crash and kill somebody, a court is most likely not going to allow that limited liability to stand, right? That's kind of a sham, right? You weren't prepared for that eventuality, and you weren't really operating in good faith. So that's what we mean by observed corporate formalities, is just doing the things that need to be done to keep the LLC or the corporation afforded that limited liability protection. Filing annual reports for corporations, that's one of them here, right? And that's one that sneaks by a lot of even really great on top of it entrepreneurs, right? They form the entity and then they forget the annual filing. And if you don't file a few within a certain amount of time, you actually can lose, the corporation be forfeited. And we've seen that happen too. So you think you have a corporation and the state's dissolved it and you're still operating. And that's a pretty perilous situation too, right? Because you don't have the LLC protection. The next item here is just strong form contracts. So what we notice a lot and what I advise a lot of startups and a lot of my clients on is they'll bring a contract that they found from a competitor or online and say, hey, look, here's what we use for these agreements. And oftentimes, they have the structure right, but all the details are completely wrong. Or, they are the service provider and they downloaded a really customer-friendly form and they don't realize that they're giving away kind of, non-standard, non-market rights to their customers. We see it all the time. So this is one area. If your business kind of uses contracts for customers or with suppliers, and you're noticing that you're using the same agreements over and over, we really recommend that you try to start from your paper, right? Not take your customer's contract, not take your suppliers, develop a really good, strong, fair form that you can negotiate from. And if you do that, what it will do is actually cut down your legal costs. I mean, there's some upfront legal costs to get that off the ground. But as you negotiate these agreements over and over, you'll get the sense of what you can give, what you can't. You'll be familiar with how deals went in the past and what was problematic. And you'll kind of keep all the rights and responsibilities neat between customer to customer or distributor to distributor or whoever you're contracting with, right? So we definitely recommend developing your own contracts, having attorneys really examine those and see what's appropriate, and really shy away from things you've downloaded on the internet or you've found another customer or another maybe competitor use, because one, they may have it wrong, and two, you may be using a form that's really unfavorable to you that you just don't know. This last point is just, it really ties into the first point too about observing corporate formalities, but diligently keep records. That's probably the least sexy thing I've said this entire presentation, which I don't know, there's a lot that are at least candidates for that. But record keeping is really important for startups. And it's not from the sense of, hey, look, it's nice to be organized and organized people are on top of it and all that. Who cares, right? I don't. I'm not organized. But when you have a buyer coming through and you have someone who's interested in your business as a startup, or you have an investor, they will always conduct due diligence. And that's one of the ways we see those deals or we see those investments fall through time and time again, because the startup can't produce the documents that they're requesting. And that's a big red flag, right? You're a startup, presumably you don't have a long operating history. And so you really should be able to get those documents to the investor, to the bank, to the buyer as quickly as you can. So by keeping records, you really put yourself in a much stronger position. It looks like we have somebody raising their hand. Yeah, go ahead, Jesse.
Jordan, thank you so much. So actually it was about about keeping records. If you're on the other side looking to invest in a company, buy in, good place to start of a list of recommended things to ask or look for.
Yeah, so this will be another plug for legal services, right? I think attorney, we have a very standard set of documents that you should be asking for to make you feel comfortable with. What we do typically is, figure out what the target is and then develop that list there. Things that are just bare bones though, right? You want to get financial statements, right? That's kind of one of the key elements, right? Preferably audited, right? But startups typically don't have those, right? And a financial statement may just be a bunch of expenses, right? I mean, it could be wild, but you want to get those. You want to get the organizational documents, right? The articles of incorporation, bylaws, all of their equity documents. So anyone they've promised equity to, anyone they've given ownership to, how the equity works, how the entire capital structure works. You'll want the cap table. That's another thing. And then you'll want pretty much all of their agreements with any customer or anybody, anything that's material to their business. You want to be able to examine those to see, they may say they have 15 customers, right? And they can produce that, but do they really, right? I mean, a lot of times we see, you might count a customer that's really producing something that's not a lot of revenue.
Yeah, fantastic. So if I came to your company and this is what I needed to get from a company, what's the term that I'm going to say, hey, can you help me obtain these? Is there a certain term?
Yeah, so I think you'd say you're conducting, buy side due diligence, right? And that would be the phrase I would use: buy side due diligence or investor due diligence. And I need these standard documents. And there's more, right? The list is longer than what I've shared.
Absolutely.
But that's a good start. And honestly, legal services are your friend. I'm obligated to tell you that. But also Google is your friend, right? There's a lot of great resources online that can kind of direct you in the right way to at least start this the process. So
Fantastic. And
yep.
you said buy side, not buy sell.
That's right. Yeah, that's right. Buy side. So if you are investing, you are on the buy side of the transaction.
Oh, buy. Okay.
Yep.
Got you.
And if you are selling, you are on the sell side of the transaction. But yeah, it's confusing with buy sell. I get that. But yeah, it's the buy side.
Fantastic. I don't want to take up more time, so continue.
Oh,
please.
no worries. Please.
Thank you.
Feel free to jump back in. So the next item here, next two items, I'm going to go through quickly. So later this year, we are planning an entire presentation on getting investment, securing it, and complying with security laws. And that's going to be a really popular one. This whole slide could be its own 2-hour presentation. But what I want to focus on is just simple tips to keep it not going spectacularly wrong. And one of those, the first line here is comply with securities laws, which is a very broad, sweeping commandment. But it's really easy to not do this. There is no family and friends exception. So anytime you're selling equity in your company, you have to fit into one of the prescribed exceptions to the securities laws, or else you would have to register your security with the SEC, right? And again, not to get too deep in the weeds with this, but anytime you're selling your equity, we recommend legal services. We recommend getting a securities lawyer that understands this stuff and can help you get through the process. Most startups are able to do it without registering, without filing a Form D, without taking a lot of administrative hassle. But there are some really strict rules that have to be followed, and in order to do that safely. The next point here is just about different investments. So this is more strategic than it is legal, but we've seen this, harm some organizations before, where you issue different equity or different debt to different investors, and without, a look back to see if it's compatible with investments that you've already made or that you've already given. So an example would be, giving convertible debt that converts on like an injection of equity, right? We've seen that a lot, but those terms really need to match up, right? Because what we've seen before is a really intense, almost calculus problem of calculating how each note would react to an investment of equity. And it's all different, right? And it's which notes are converted first, and then if all the notes say they're the last to convert or the first to convert, which has precedence, the first there or not, or the first note that was issued or what? And it's really, it can get really messy quickly. And my third point here bleeds into that point is, so don't rely upon your investor. If you're the business, please do not rely upon your investors' attorneys to draft the documents for your business. That's the business's equity. That's the company's equity. You really need to make sure that your investment plan is compatible with what you've already done. So you're not going to give equity that has rights and responsibilities that are not enumerated here, but you enumerate them there. And so people are fighting about who has the better voting rights, but none of this is written down, right? All of this has happened to some degree to our clients, and we've seen it. So that's just another plug for legal services. There are certain things that I think entrepreneurs fairly can do on their own and are at less risk for. This slide is not one of them. When you're selling equity, things can get serious pretty quickly. And if there's a disagreement, not only can you have a lawsuit from your shareholders or from your members of an LLC, but you can have problems with regulatory authorities too. So always make sure you're complying with the securities laws. It's always money well spent, in my opinion. Make sure not to issue different instruments and equity investments that aren't compatible, that would vest at different times, or that would vest incompatibly. That can just be really messy and it scares investors away. And then just, again, like, don't let someone else draft your documents for you. It's okay if they want to start the draft, but always have the company's attorney or an attorney that you hire make sure to take a pass at those to make sure legally it all fits together. This is just another plug that I see a lot, that when someone takes on investment, they can be surprised at exactly what you're giving up. And so unfortunately, right, the life cycle of a startup, the early life cycle is, hey, we have to get money in the door, right? And there's a pressure to do that almost in any way you can, right? And so oftentimes we've seen startups take on investors that take a lot of managerial authority with a small ownership stake. And so you really need to be keen on what you're giving up. Understand that when someone's investing in your business, you are assuredly giving up some rights to management of that business. But you need to understand exactly what rights you're giving up. We've seen it before where a 10% owner has pretty much a veto right over all major decisions of the enterprise. And that's not a position you necessarily want to be in, unless that 10% owner is worth that hassle. I mean, that's happened before too. So always understand what you're giving up when you accept investors. Keep your cap table up to date and keep it accurate. I've spoken with a few startups that send a monthly report to their investors and to their owners of the cap table. So the cap table basically just shows the ownership of an organization at any point in time. So exactly, what's been issued, who owns what, and then usually percentage of ownership by each owner or member of an LLC. This, wildly enough, can be one of the most problematic things we've talked about today, where a cap table, someone is just not keen on keeping it up and doesn't want to take that effort to, when they issue new stock to someone or give someone options, to reflect that. And then your records get messy and it becomes very difficult to track exactly who owns what. And again, when you have buyers or investors coming in that are interested in your business because your business is very good, this is one of the things that can scare them away, when you can't quickly and accurately tell them who owns the business or what we've promised to give. So always keep your cap table up to date. Always keep all of your ownership information completely up to date and readily accessible. I like the idea of giving your partners and your owners a monthly or bi-monthly report, just showing these things to kind of establish a record. But that's not necessary. What is necessary, though, is to keep your cap table completely up to date. The last item you'll see is struck through to indicate to never do this. Do not give any oral promises to equity. Obviously, it's okay to talk about, hey, I really would like you as a partner. Here's what we can do. We can offer this amount of equity for this. Let's talk about it. Let's get a deal in place. Let's negotiate it. But what you should not do is in the early stages say, hey, we are short on cash. We need you to do this. And I promise you, we'll give you 20% of the company later, right? Because that is a recipe for an absolute disaster. Again, If it's not written down, then it's really tough to determine exactly what the ownership would be. And so we would just recommend, strongly recommend, that any sort of offer of equity, any sort of discussion about compensating someone with equity or bringing them in as an owner or partner, please do that in writing, do it clearly, and really past the preliminary stages, do it with an attorney at your side, or at least monitoring the communication and making sure you're doing it appropriately. Any questions on the past couple slides? Okay, so the last slide, again, sorry to disappoint. Tara Ficken was here last month, I believe, maybe 2 months ago, or she's coming next month. Tara's on her way, or she's already been here, about intellectual property. She's an IP attorney, I am not. But we have seen this acute issue that I'm going to talk about at the very bottom here with a lot of startups. So in a presentation about issues that startups face, I do think this is relevant. So most of you on the call probably understand the different types of protection for intellectual property. So you've got patents. These are basically inventions. A patent is issued by the USPTO. It is basically a monopoly on an idea or an invention that you get for a certain amount of time to capitalize on it. Trademark is the logos, they're marks used to identify goods in the marketplace. Trademarks exist outside of getting a registered trademark. They can just happen by using a mark in commerce, but they also can be registered by the USPTO. A copyright happens automatically. Again, it can be registered, but it is kind of an automatic bylaw thing. And that's when you're creating new materials, you're creating a book, an article, you've created a movie, anything like that, right? New works. And then a trade secret can really be any information or process or formula or any kind of secret that's important to your business. Importantly, obviously, it's a secret, right? So it's not filed and it's kept very in highest confidence. So to keep trade secret protection, what's important here is, there's a lot of startups that are built on trade secrets, not necessarily patents, but we have a better process. And to keep a trade secret, you have to really be exhaustive in the measures you go to keep that trade secret a secret. That's the formula for Coke, right? It's not patented because if it were, after the patent expired, everyone could make Coke formula, right? So a trade secret is just any sort of thing that helps your business, any idea, information that you're keeping absolutely secret. Where we see this go wrong. So in the starting phases of a business, let's say you have a couple of people that are creating a software business, and one person is the interface programmer, and the other person is kind of the back end, the code that actually drives the program. And you haven't formed an LLC yet. You both just got together and said, hey, here's this idea, let's do it. The problem can be who owns that IP, right? The organization doesn't exist, and maybe one person owns the interface, one person owns the code, but it's not clear, right? And then you realize later, you listen to this presentation and say, we got to get an LLC. So you form an LLC and then you start marketing this code and this software through the LLC, but you never officially agree between the partners that the IP belongs to the LLC. Well, if something goes wrong later on, you can have a really big problem in a dispute about who owns the IP. The way you get around that is that you agree in an assignment of IP agreement, or there's lots of different ways you can, lots of different agreements that can get this done. But the idea is that the owners who develop the IP would get together and say, hey, look, this IP is stronger in the business. Let's agree that the business owns this intellectual property and that we don't own it individually. We're owners of the business, so we still, reap the rewards of that. And what that does is it just avoids a nasty fight down the road of two owners that maybe don't get along and maybe have a fight about who owns the intellectual property. And so that is my only plug on IP, is that when you're thinking initially through this, it's never too early to get an assignment of an invention or to get assignment of intellectual property of whoever you're using, whether it's a contractor, whether it's, a partner, whoever is contributing to the business, right? Get an assignment of that intellectual property into the organization's name. It's of vital importance and will save you a lot of headache later.
All right, I think in the interest of time, we'll go ahead and end the session. So thank you so much to Jordan, first of all, for coming here and giving us a talk. I think it was super informative for everyone that was able to attend and participate. Other than that, thank you all for your time, and I hope you all have a great rest of your night.